Well, we will go ahead and get started since it is right at 11 o'clock. Today's webinar is being recorded and I'll put it on my YouTube channel. And if you couldn't attend, if you signed up, you'll get the link. But otherwise, it's going to be on my YouTube channel, so you can always go back and watch it. Today, we're going to be talking about when does your estate plan need to be updated. We've kind of mentioned this before in previous webinars, but I wanted to dig a little deeper just into this updating your estate plan and those type things today. So, a little bit about me. If this is your first time joining me, I'm a graduate of the University of South Carolina, and I'm a graduate of the University of South Carolina School of Law. My main areas of practice are estate planning, Medicaid planning, special needs planning, and business planning. So that is why I'm hosting this webinar today on estate planning. So we will dig into this. So the overview for today is we are going to just go over estate planning real quick, just to kind of do a brief update on that. When to update your estate plan, and say you've made an estate plan and you have a trust. When do you need to update that trust? What do you need to do to make sure you've actually properly funded it? Maybe you set it up 10 years ago and haven't thought about it. So we're going to dig into those topics. So the first thing is, I've done some webinars on this before, but if this is your first time coming, just what is estate planning? So estate planning is creating documents to handle how your assets will be distributed at your death, such as through your will or trust. And also, when we're talking about estate planning, we want to talk about the life planning asset too, which is estate planning and part of it, but it's creating documents that are going to affect you during your life, such as your durable power of attorney and your healthcare power of attorney. So estate planning is using your wills, your trust, your powers of attorney, your durable powers of attorney to have a plan for you, for one, to distribute assets at your passing, but secondly, to have plans for your life. So if you become incapacitated, somebody can act for you as financial reasons with the durable power of attorney, or somebody can act for you for medical reasons with the healthcare power of attorney. So if you haven't done an estate plan, it's important to get this taken care of and make sure you have that estate plan in place to help you if something happens where you are either incapacitated or you're dead. So many times people focus on the will and trust, but I will say those powers of attorney are just as important. If you don't have a power of attorney and you become incapacitated, that's when your family is going to have to go to the probate court to get a conservatorship or a guardianship. And those are very costly and time consuming proceedings sometimes. So these two documents can really make a huge difference. But that's the little basic on what is estate planning. So we've talked about what documents are in an estate plan. A lot of times that's the will, and the will is going to decide how your probate assets are distributed. So that's where you list your beneficiaries for those assets passing through probate. And we've done a webinar kind of on what's probate and probate 101. So that may be helpful if you have questions about the probate side of things. You have your healthcare power of attorney, which is allow somebody to act for you if you're incapacitated and can't make decisions for yourself medically. And I think that is super important to be able to have in place, is that healthcare power of attorney. So that way you have somebody to make decisions for you. The durable power of attorney is for financial decisions. So you want to have this if you become incapacitated, or if you just don't want to act for yourself anymore, somebody can make those financial decisions for you. And I think it's more important to have this document because than putting somebody's name on a bank account with you, because this means it's still your assets. They don't have any control over it. They just act for you. Sometimes you're going to think about having a trust because maybe you want to avoid probate, or maybe it's the fact you have children that don't know how to handle money, or maybe you're kind of wanting to control things a little bit more on when you have assets distributed, maybe to grandkids or to a spouse, or have your spouse get X amount for life, then go to your kids, those type situations. And a lot of times deeds are part of your estate plan as well, because you're setting up a trust, or maybe you're setting up a life estate, or you're setting up a deed so it's joint tenancy with right of survivorship. Because it doesn't really matter what's in your estate plan, sometime in your will or your trust, if your deed isn't matching that. So for instance, if your will says you give all your real estate to John Doe, but your deed has that you own it as Jane Smith and John Smith as joint tenants with right of survivorship, what's on the deed is going to control in that situation. And this is going to go to John Smith because the deed says it's with right of survivorship. So it's important to make sure all these different pieces of your plan match together. So not just the will, but making sure the trust or the deeds and the powers of attorney all come into play. So you've got this estate plan. So we've talked about estate plan, and a lot of you have probably already done this estate plan, which is why you're joining in today, is to learn about when you need to update it. So with that in mind, the biggest time to update your estate plan are when you have life changes. So when there's a death, is this person somebody you had listed in your plan? Did you have contingents for them? Or is this a person that was your PR of your personal representative of your estate or a trustee of your trust? And if so, did you have backups? If you didn't have backups, it's a good time to look at updating that. Is there a birth of a child or a grandchild or a niece or nephew or even a friend that you want to add as part of your estate plan and you want to make sure they're covered? Are you about to get married? Or is this a first marriage where there's no other people involved? A lot of times, maybe there's no other, you don't have children yet, you're young and you're getting married for the first time. So you need to put this estate plan together for the both of you. Maybe this is a second marriage where you have children from a previous marriage and you want to make sure you're protecting those children with your estate plans. That's a good time to check in with your estate planning attorney and possibly even a family law attorney so we can talk about your estate plan working with a prenuptial agreement as well. Have you had a divorce recently? Is your spouse still listed? Do you want your spouse still listed? Do you want to change that? I think these are the biggest times we think about changing our estate plan is when we have these life-changing events. And they're not just negative events like we've talked about. They are positive, marriage and birth of new family members type thing. But we need to still update it to make sure our plans match. Um, and when we think about this, it's not just simply your will and trust, but your powers of attorney. So with your powers of attorney, we want to make sure that we are having the powers of attorney updated too. So if somebody is having their power of attorney is not who they want it to be anymore because there has been a divorce or there's a new marriage and you want to add your spouse or the person that you listed as passed away and you didn't have contingent. So it's not just thinking about with your will or trust, but your powers of attorney as well. So if you're getting married or you're divorced, you want to update those documents as much as anything else too. And also with all of this, you're going to need to look at all your beneficiary accounts as well as it's not just your trust and will, but how do you have your accounts at the bank named? Do you have somebody else on it with a joint right of survivorship at the bank so that maybe it's not working with your plan like you thought it was? Did you name your trust properly on your bank account? And do we need to update that? Say you switched banks. You maybe were banking with Bank A and you decided you moved to a new city. Bank A is just not there. It's not as easy. So you want to switch to Bank B. Well, when you switch those accounts over, did you make sure you named them properly? Did you put it in the same name it already was? Did you change things that could impact your estate plan? So when you make these decisions, it's sometimes good to check in with your estate planning attorney to make sure everything you're doing is properly funded here. When you buy a new house or when you're getting new real estate, that's also a really good time to check in to make sure that real estate is titled properly. A question I just got from somebody was, how should I have my name listed on the deed to my house because I'm getting divorced and I want to make sure that I remove my husband's name. So this is an area I've dealt with a few times recently. Sometimes you get divorced and while it says that spouse A or wife gets the real estate and husband has said, yeah, we've agreed to it, but maybe you haven't changed your deed yet, and maybe that didn't happen with part of your divorce. Maybe it was because you couldn't get the mortgage in your name. So you're making your husband stay on it to keep the mortgage rate the same. So at that point, maybe 10 years have passed, the mortgage has been paid off. You're going to want to do a deed to get your ex-husband's name off the deed and just get it in your name. So that way it matches your estate plan, whether we need to put it as just your name, whether we need to think about it being in a trust for some probate avoidance. But that's a lot of times people in the divorce process will have the house decided, but maybe they don't have the deed updated to how it should. Then we have another time you want to have it looked at is when there's changes in laws, especially tax changes. A lot of times we're seeing the state plan. If your estate is taxable or not taxable at the time you create it, that may create what your plan is. And so with these changing tax laws, you want to make sure that if you do end up having a taxable estate, you get your plan updated to that. Maybe you don't have a taxable estate anymore and you want to change it. I think it's always important to change and make sure your plan works with the current tax laws. And our usual recommendation is just to check in every 3 to 5 years to make sure that, tell me about your life changes. Tell me about some financial changes. Tell me about buying real estate. Tell me about maybe you've inherited some real estate from your family. So it's kind of a good time just to think every 3 to 5 years to make sure that that plan is up to date. So if something happens to you, your assets are distributed how you want them to be distributed, but how you think they should be distributed based on the plan you have in place. So this is kind of going into a little bit more about when you're changing bank accounts, investment accounts, etc. So when you open a new bank account or switch banks, you want to make sure you keep the same plan in place. So like if you had decided originally you're going to have your bank account in the name of your trust you created, well, when you switch from bank A to bank B, you're going to make sure you want to make it that trust account still instead of just putting it in your names, because that may change your estate plan. Also, you want to make sure if you're having a POD account, known as a payable on death account at Bank A, where we talked about maybe just leaving your children as the POD on the account, then you're going to want to make sure when you switch to that different financial institution that you have the account set up the same way, because these payable on death and how bank accounts are titled make a huge difference in your estate plan. So you're going to want to make sure you keep those the same, or check in with your attorney to make sure as well that that's how your plan's set up. The same thing when you're transferring financial institutions for wealth management or changing your financial advisors. Say you're with one company and your financial advisor that you've been working with is leaving and going to a new company. So you're following them and going to this new company. Being that they've worked with you, hopefully they know how all your plans were set up. But you may need to just double check and make sure when you set up these new accounts at this new financial institution, we have it set up the same way as you did previously. And if you're changing financial institutions, you're moving from one company to another with a new wealth manager, you may want to let that wealth manager have a call with your estate attorney to make sure that everything's working for the total estate plan. It's a group effort on estate planning. It is not just an attorney drawing the documents and a financial planner and an accountant all in different silos. We all work together to create the best plan for you, and making sure that we all know what each one is doing can be a huge benefit to making sure your overall plan is completed. And if you are completely opening new and different accounts, that's maybe a good idea to say, how should I title this account? What's going to make it work best for my estate plan? And a lot of times, buying new property is a big time when you're going to deal with your estate questions, because how property is held, what is on the deed, makes a huge difference. So when you're buying this new piece of property, how did you have it previously owned? Did you understand how it was titled? In South Carolina, for many years, the default was just for a married couple to put Mr. and Mrs. Smith. Well, that means you only own half of the house, not the whole house. Times have changed, and more attorneys, closing attorneys, are going into putting it Mr. as Mrs. Smith as joint tenants with right of survivorship, so it passes outside of probate to each spouse. So when you're buying this new piece of property, do you want it to be joint tenants with right of survivorship so it goes to each other outside of probate? Do you already have a trust in place? So does this mean when you buy this new property, you need to go ahead and put it in your trust like your previous piece of property was on, or maybe you're just getting a new piece and not selling an old piece, but you want to make it match? Is this something you want to do with a life estate deed, that you own it for your life and then at your death it automatically transfers to your children or your beneficiaries? Real estate tends to be one of your bigger assets, so it is important to make sure you properly label it as such. Like we talked about before, what is on the deed is what controls. It doesn't matter what you've said outside of it. It doesn't matter what you wish to happen. What's on the deed? So what I mean by that is how we talked about a minute ago. If you want your property say you're remarried and you're now married, you're Jane Doe and you marry John Smith and you are buying a house together. And on the deed, it says joint tenants with right of survivorship. But in your trust, you wanted everything, your half of everything to go to your children. You didn't want it to go to your new spouse. But since it says with right of survivorship, what's on this deed controls, so that means it's going to go to John Smith. If you wanted it to go to your trust, maybe your half of the property should have said Jane Doe Revocable Jane Doe, trustee of the Jane Doe Revocable Trust, and John Smith. So that means your half, it's going to go into, it's in your trust and will be distributed the way you want it to be. So with real estate, it's always a good time. And while you have an attorney that does your closing, you definitely want to talk to them about how it's being titled. And if they're not an attorney that deals with estate planning as much, maybe they're simply a real estate attorney, then you may want to have them give a call to your estate planning attorney or talk to your estate attorney so that way you can make sure this new piece of property works properly with your estate plan. I think the biggest issue I've seen with trust is people kind of forget what to do with it or that they have this trust. So a lot of people tend to set up a trust and forget about it. So when you set up this trust, a lot of times you're only funding the trust with the assets you own at the time. So continuing to fund your trust and make sure as new assets come up or as new property, everything comes up or you switch financial institutions, you want to make sure that your trust is still being properly funded. So you want to kind of check in every 3 to 5 years to make sure you're still funding it. Because if you buy new properties after the fact, or there's something you didn't mention to your estate planning attorney and it's not funded into your trust, you may not get the benefit of your trust and you may not get what you want in the long run. So most time when we think about what should typically go in a trust, a lot of times we're going to move that real estate into it via deed. We're also going to think about possibly putting those bank accounts in them, even having it owned by the trust, or maybe the trust being payable on death. Investment accounts, we're going to look at those in kind of the same way. Vehicles, we can talk about that. A lot of times we don't put vehicles in a trust for insurance purposes and those things. But if you have maybe a collector's car or something to that extent, we may want to put it in the trust. Life insurance is beneficiary controlled, like the investments account. Do you want that to go straight into the trust or do you want that to go to your children directly? And I think that's a conversation to have with your estate attorney and your life insurance agent. So we also can sometimes think about retirement accounts. Do we want those going through a trust or do we want them to go out individually for tax consequences? We may think of just leaving those to beneficiaries and not running it through a trust. If you have a business, you may want to make sure your interest in the business is in your trust so that doesn't go through probate. So I think when you set up your trust, you've probably looked at putting your real estate in it at the time, and you got instructions maybe to put your bank accounts and different investment accounts. But as things have changed, maybe you set up this trust 10 years ago and you haven't looked at it or haven't added assets to it. That may become issues for your family if something happens to you with your trust. So one thing I say is anytime you're doing any of these things, you want to make sure you're still properly following the plan set out. I have many clients who may have moved here from a different state, bought real estate here and didn't put it in that trust they'd set up, or they've just set up a trust maybe 20, 30 years ago and haven't thought about it since, but a lot changes in that time. A trust is a living document, so we want to make sure that we treat it as such. I do have a question. Does life insurance go into my trust or is it paid to the beneficiaries when I pass away? So whatever is listed as the beneficiary on that life insurance, that's where it's going to go. Same thing with payable on death accounts, same thing with investment accounts that have beneficiaries. A lot of times people think it's automatically going to go through their estate plan, but there's beneficiary designations control. And so if you want it to work with the trust and the trust you've created, we need to make sure that the trust is either the beneficiary or it's owned by the trust. And I think that's really important when you're thinking about doing this estate plan is we're setting it up for what it is right now, but as life changes, your documents may need to change. We may need to add things, take things out of the trust. So that's something that you really need to think about with your trust. It's not do it and it's done forever. It's think about, okay, well, life's changed. I've got new property. I have new bank accounts. Let me just check in to make sure I'm still properly funding it so my family gets the benefit. Another time we want to think about possibly dealing with our trust is sometimes with changing Congress and presidents, there's different things that change a trust. For instance, tax regulations, like we talked about before, with the Secure Act, it's changed how RMDs and beneficiaries can handle taking out these deferred tax accounts. So, with those, your trust may have been set up the best way previously to handle a retirement account, and maybe it's not anymore with changing tax ways. And that's times you also want to look at things if you're doing charitable planning and those type things. When there's new tax laws that change, it may be advantageous to do different ways of charitable giving, or it might be time to set up a life insurance trust that's irrevocable to help as part of your overall tax plan. So right now our exemption is still really high. So a lot of us aren't having to worry about the tax plan. If you are, you have a lot of good problems to deal with. But if you're not, it's 22 million for a married couple, 11 million for a single person. So with that, most of us aren't dealing with it, but that doesn't mean that that's set in stone forever. It's going to change at some point, and at that point, you might want to look at making sure your estate plan is still properly handling things with the changing tax laws. So overall, I want to keep this webinar pretty short, but my final thoughts on this for everyone is your estate plan is a living document. Make sure you treat it that way. While yes, a lot of times you may not need to update it. It may be good, but don't ever just put it aside and never think about it again. Make sure every few years you're looking at stuff and making sure if there needs to be changes. If you know there's been births, deaths, marriages, tax laws, all that stuff, you've made changes, you've bought property, you've changed financial institutions, you've changed financial advisors. All of that stuff makes a difference to your estate plan. I will say, I don't recommend people getting out their original will. So when you get a will, have them either send you a digital copy or a copy of it, because if you pull out that original will and don't put it back in a safe place and it's lost, that makes a huge difference because probate needs the original will. So look at a copy and don't handwrite on your will. If you want to make changes to it, make changes the proper way. Do not just handwrite on it and think that that's going to be accepted by the probate court. Make sure your trust is properly funded. So you've put a lot of work and a lot of money into setting up this trust. You don't want to just let it slide by and not have it properly funded at your death. So it's important as you go along and you've everything we've talked about with property, accounts, everything is making sure you're still funding it properly to the trust. So your trust was created for the assets you told your attorney about on the day you created it. But if they didn't know about those assets, or further, if you acquire later assets, they may not be in your trust, and you want to make sure they are because you put a lot into this trust. So pretty much, I think checking in with your team of professionals, your accountant, your financial advisor, your attorney about your estate work every 3 to 5 years to make sure you didn't miss anything. Because the last thing you want to do is have set up this will and this estate plan to where, or this trust, to where you think everything's going to be distributed properly, and then it causes an issue for your family, or maybe even an issue for you if you and your spouse, if your spouse predeceases you and you didn't have everything set up properly. So I think it's really important to make sure that you treat this as a living document, and as life changes, you may need to change it, or you may need to come do some updates on funding of your trust. I did have one other question. Do I need to have my current financial planner or my financial institution listed in my estate plan? And that is kind of up to you. Some clients want to make sure that they list that, John Doe is their financial advisor and you'd like for the trust to use him. It's personal preference. I would say you need to have a list of these people, even if not in the trust, for your family. So wherever you have your bank accounts, whoever is your financial advisor, where you have your life insurance, all these things need to be known to your family. No, you don't have to tell them during your life, but have a place where you've listed your contact information for everything. So that way, when something happens, they know who to go to, who to call, and where your assets are to make it a lot easier for them. So I normally recommend having business cards for your life insurance agent, your financial advisor, your accountant, your attorney, all with your estate documents. And as those change, make sure you put new cards in for that as well. Or maybe you have a spreadsheet with all this listed, and you need to have a spreadsheet where all your bank accounts are as well. So that way your family isn't confused. And if you have a confusing property situation, I've had a few clients recently have some real weird issues with property. It may be good to write an explanation of everything to your kids. So if something happens, they kind of understand the history of it as well. Those are all things that I think are important with your estate plan. Does anybody have any other questions? Well, thank you all for joining me today, and we will get this posted on my YouTube page. We'll try to get it on our website as well. But as always, feel free to give me a call or an email. Once again, I'm Lauren Ward with a business law firm, and I'm happy to help with any estate planning questions or needs. And feel free to email or call me. And I'm glad you all could join us today. And if there's any other questions, feel free to ask them or send emails or calls. But I hope you all have a wonderful Wednesday, and we'll be putting on another webinar next month that we would love to have you join. And if anybody has any topics they want covered in webinars, feel free to send them to me in an email, and we'll definitely look at having those covered in the future. Well, I hope you all have a wonderful day.